Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Amanda Hamilton, and today's topic is, what do the updated HSR rules really mean for your next deal? In February 2025, FTC and DOJ implemented significant revisions to the pre-merger notification form and associated rules under the Hart-Scott-Rodino Act. The updated rules prompted numerous questions among antitrust attorneys regarding their practical implications for preparing an HSR filing. During today's episode, our guest will share his insights gained from navigating the updated rules. Joining me today is my co-host, Puja Patel. Puja, who's our guest today?
Thanks, Amanda. Our guest today is Brooks & Gray partner Zak Goodwin. Zak is an antitrust lawyer who, among other things, advises clients on antitrust issues in M&A. He advocates for them before the DOJ and FTC. And before his time at Brooks & Gray, Zak was previously an in-house antitrust lawyer at a global life sciences company. And he's also spent time earlier in his career as a trial attorney at the antitrust division of the DOJ. Welcome, Zak.
Thank you. It's great to be here. Thanks for having me.
Zak, let's start off by discussing the role that HSR rules play in merger review.
Yeah, so just at a very high level for those who don't kind of live and breathe it every day, like some of us do, HSR or Hart-Scott-Rodino Act is the set of rules that govern, which transactions have to be reported to the government and what you have to report to the government when you do one of those transactions. So at the highest level, that's what we're talking about.
And Zak, we have listeners here who may have not sort of dabbled into the HSR rules. What are your top 5 learning challenges that you've experienced from the new updated rules now that we've sort of been in them for a good 10 months now?
Yeah, so good. I mean, I think it really depends a little bit on what type of client you are, what type of company you are, which lesson is sort of the most interesting to you. But kind of the 5 takeaways that I think I have, having been working on these for the better part of a year. First, I do think that the increased disclosure requirements can, in certain circumstances, lessen the need for sort of a short investigation or an access letter, that you might have seen under the old rules. So that's one. The second is that pulling, vertical supply data can be a giant pain, depending, again, on the type of company you are and the way your business is structured. But that can be kind of a long pull and really quite painful. The third is that the supervisory deal team lead as a custodian, which is a new requirement. We call it SDTL for short. That, to me, has been by and large manageable. I think early on there were some questions about how confusing that would be, how much burden it would involve. And I think, for the most part, it's been manageable. That's not to say it's without issues and without some burdens, but it hasn't been, hugely painful in the way that it might have been. So the fourth is that just emphasizing, preparation, even before you have a live deal, can be massively helpful, both in terms of, the speed that you can pull together a filing and the certainty with which you do so. And then the fifth one is that, how much time it actually takes to pull together a filing and submit it to the government. It can vary really widely depending on the type of deal that you're doing and the facts behind the deal. So those are kind of like the 5, big picture things that stick out to me.
Very helpful. And I think we're going to want to distill each of these because I think there's a lot more behind there. So maybe focusing first on the first one you talked about, which is that they could, in certain cases, make voluntary access letters, shorter investigations unnecessary. Can you talk a little bit about what it is about the new rules and the new disclosures that can help in certain cases?
Yeah, I mean, so I think it might help to start by talking a little bit about what it was like under the old rules. So under the old rules, I mean, the substantive information that the government got was what we called Item 4 documents, which, to summarize it, very, very generally, was, documents that assess the deal with respect to competition and are shared with officers and directors. So that was really the substance that the agencies were getting. The form itself has some revenue information, but it's usually not particularly helpful for them in deciding, does this deal have issues? So, I remember back to the days when I was at DOJ, and occasionally you have to review these filings, and sometimes you just get a filing and you really don't know what it's talking about. I mean, they're using, abbreviations that you have no idea what they are. It may be in a space you've never touched. You can Google around, and that sometimes gets you what you need, but not always. So it's that type of situation where under the new rules, you kind of have an opportunity to sort of explain if there are overlaps, what those overlaps are, and a little bit how to think about them. Same thing with vertical relationships. If there are vertical relationships, you can kind of explain them a little bit. And then, there are more documents if you have an overlap that you have to put in, including ordinary course documents. And that can just shed light on some of this kind of basic factual information that otherwise you either would have to rely as the government on the internet or you'd have to reach out to the parties. And so I think in that type of circumstance, the government can kind of look at the overlap description and see, okay, there's just no overlap, or okay, the overlap is in some very fragmented space and there aren't really going to be competitive issues here. So they don't have to reach out, and they otherwise might have had to reach out, which, I think is a good thing. It also gives you as a, lawyer representing the parties an opportunity to try to, explain to the government why they don't need to reach out. Obviously they have the documents too, so it's not just that little overlap description, but I do think that is to some extent a benefit of the new rules.
I remember those days well as an FTC attorney, practically searching the internet and being always concerned if I was going to get this wrong or not. But so clearly the updated rules have some benefits to the agencies, but let's focus on pulling supply data. Can you start by giving the audience a bit of background on what the updated HSR rules ask about in terms of supply data, vertical data?
Yes. And it's almost hard to state this very simply, but sort of two categories of supply relationship information. So one is sales that one of the parties to the deal is making to the other party or to the other party's competitors, where you think those competitors might be using that product to compete with the counterparty. So that's one category. The other category is sort of the flip side of the coin, which is purchases that you make from your counterparty or from your counterparty's competitors with respect to a product that is, competitive with the counterparty. The idea is obviously, to investigate whether there are any real vertical theories of harm. So whether you might, have an incentive or an ability to foreclose competitors after the transaction. So that's what the rules require. That can be very, very difficult. For some clients, it's very easy. I mean, if you're kind of a pre-commercial biotech, you're probably not going to have a whole lot of these types of relationships. But if you are a really big company, especially if you were sort of, maybe built by M&A and you have all sorts of different businesses and different, data systems, finding out what your sales are to a particular company sometimes is actually quite hard. You have to talk to a whole bunch of different people. You have to make sure that, the data is not double counted and all this stuff. So this is one of those areas where prep helps, I think, because you can figure out what your sources are and try to, understand them and make sure they're consistent even before you have a filing. But it can really be a long pole when you're putting together a filing. It just requires input from a lot of people sometimes.
I also find the challenge is trying to figure out the competitors of the other side, especially in areas where your client may not compete with them. This is reminding me, again, Zach, thank you for the reminder of what a mental pretzel these vertical supply relationship questions tend to be. Maybe switching gears to the supervisory deal team lead. I think this is one that always, raises some questions from clients. What does it mean? There are lots of follow-on questions that I'm sure you've seen too, but can you just talk to us a little bit about what is a supervisory deal team lead and what challenges you've seen in trying to figure out who that right person is?
Absolutely. So, I mean, under the rules, the definition is an individual who has primary responsibility for supervising the strategic assessment of the deal and who would otherwise not qualify as a director or officer. So that's kind of the black letter, what the rule says. I mean, typically this person is the person who's really leading the diligence effort and, overseeing the team that's doing diligence and assessing the target. At a kind of big strategic company, it's often the head of their corp dev or business development department. Not always, but that's often a fact pattern that you see. Despite the sort of maybe vague and broad description that the rules give about who we're talking about, I mean, in my experience, it's usually pretty easy to identify who that person is. It's usually pretty clear. It can be harder at a very small client that is just sort of dividing responsibility among 3 different people and no one's really taking the lead. You have those sort of situations where that comes up. But by and large, it's been relatively straightforward. One point to make is that in certain circumstances, it is just the case that the person who is the supervisory deal team lead is a director or officer. So you see this sometimes in PE, like an IC member is the guy who's doing the deal. And it turns out that's fine, which is good because you kind of don't need to and can't just make up another person who is doing the supervisory deal team lead work when that person is not doing that work. So just as a matter of reality, sometimes you're not even really adding a custodian because, the SDTL would have been a custodian under the old rules. The other thing I think to keep in mind is just, under the proposed rules, there was a lot of discussion and debate about what drafts, to the supervisory deal team lead would and wouldn't be responsive. And there was some fear that it could really turn into an absurd exercise. For example, if you have to put in every draft, well, some cloud systems record every keystroke. And so what are you handing in millions of basically the same document? And I think the final rules and the way that the practice is played out is that has been less of an issue than people expected. Generally speaking, it's, drafts that go to the board or individual board members, or the final version that sits in the supervisory deal team leads files, which I think is more manageable than it could have been in an alternative world.
Let's go to your fourth takeaway, prep work. So antitrust tends to be incredibly fact specific. That certainly includes deal review. So given this, prep work can have a little return on investment at times in antitrust. And what ways have you found prep work has been helpful in complying with the updated rules?
Yeah. So, if you have a live deal, you should always, I think, at least start to think about this as soon as you can. But I think there's a lot of prep work you can do even before you have a live deal, particularly if you're a large company that has a bunch of different systems. We talked about the kind of, vertical supply relationship data. You can do work before any deal is even on the table to kind of identify, all right, what systems do we have that would give me this data? Can we organize it better than it currently is organized? Can we make different, you might have multiple systems. Can we make them consistent or consolidate them into one system so it's easier to pull? That's all work you can do early that makes your life a lot easier when you're actually trying to pull the data and put together a filing. Also, just identifying the individuals who know these systems and have access to the data. So when you have a filing, all right, I'm going to talk to, John and Jane about this particular issue, and they'll be able to get the information to me. You can, come up with timelines so these people know when you have an HSR filing, they'll need to go, X amount fast, that sort of thing. So that's one thing. I think identifying the types of documents that might be responsive. So just, for example, certain ordinary course documents have to go in, documents that are shared with the board that cover kind of relevant subject matter, and regularly prepared reports that go to the CEO that cover relevant subject matter. You can get a sense of what the universe of those documents might be. For example, companies often have a very specific platform that they use to share documents with their board. Knowing that is useful because then you know primarily where you have to look to see if anything is responsive. Often companies have sort of a regular cadence of reports that they provide to the CEO. knowing what those are and what kind of information they have is useful, when you're trying to pull information. That way you're not starting from scratch and have to find everything on a very tight timeline. I mean, if you're in an auction process, this would be quite difficult. A few other areas that are really more specific to certain clients and may not be as impactful to others, subsidies from foreign governments of concern. I mean, you can identify those, before a deal is happening. Reporting on defense and intelligence contracts, that was a new requirement. You can identify that stuff before you have a deal, and it just makes it much easier, when the deal comes along. You'll have to update all this, but having that groundwork makes it much, much smoother and faster. And if you're a bidder, that can even differentiate you. I mean, if you can get a deal done faster, sometimes that means a lot to a seller.
Zach, maybe touch upon this timing point. How have you seen the new rules impact, the time it takes for parties to prepare and submit their filings? I mean, is this something that clients can knock out in a week or two like they could in the old rules?
I would say in some circumstances. Look, on average, it takes more time, maybe significantly more time. I would say kind of under the old rules, it was sort of 5 business days, maybe 10 business days in that range, from signing to the time you submit your filings. Now I feel 20-day business days I see more commonly. I wouldn't say that's a standard, but that's one that I see pretty frequently. It really depends on how complicated the deal is, whether you have overlap, whether you have supply relationships. It depends a little bit on the structure and the entities you have involved and, how many people you have to go ask for information. I would say in a simple deal, you can get it done, maybe much faster than 20 business days, especially if you have time before you sign to really get the wheels in motion. So it just varies. The other thing to remember is, you're only on the clock with the government once both parties file. So part of this is making sure that the other party that you're about to do a deal with is kind of ready to go and make sure that they kind of know how to do this and how to do it quickly. But the real answer to your question is it varies quite a bit. In super complicated deals, you might not even have a business day, timer in the agreement. You might just say as soon as reasonable and practicable, which is kind of similar to what you see outside the U.S. sometimes.
Zach, do you have any other good intel to share with us about the new rules?
Yeah, some other stuff that just comes to mind. I mean, one is that early termination is back, which is great. I say that we're in a government shutdown right now. It's not back as we speak. It was back before the shutdown. I would expect it to come back after the shutdown. I've seen numerous deals get ET after a couple weeks from filing. I don't know if that counts as being part of the new rules, but they definitely reinstated it, with the new rules at the same time as the new rules. And frankly, having some of the overlap information we talked about might make them more comfortable granting ET when they otherwise would feel the need to sit and wait. One of the changes was that you can't file on a bare bones LOI in the way that you maybe could have under the old rules. I think some people wondered whether this kind of, beefier LOI requirement was going to kind of deter people from filing on LOIs. I haven't really seen that. It feels like people are still filing on LOIs. Yes, they have to be more built out. They need to, give more information about what this deal really is. I do think you see, at least historically, you would see a lot of LOIs come in at the end of the year. So, we'll see over the next, several weeks whether that pans out this year. But I haven't seen some massive decrease in, LOI filings because of the new rules. What else? I would just say that the agencies have not been super sticklers about purely technical stuff. Sometimes they will make you, I don't know, for example, just provide more information on a business description, But I haven't seen them bounce filings for that very kind of technical background data. which is good. I mean, I think part of it is like they probably recognize these are new rules, so that people are learning them and they're letting people learn them. On the other hand, I would not doubt at all that they will bounce filings that are missing kind of key substantive information. So that's not at all what I'm saying. I'm just saying that, if they disagree with you about some very technical interpretation of just how much you need to describe the business or something, they might ask you to do more with it, but they haven't been punitive, about that type of issue.
Zach, that's been incredibly helpful background. Thank you so much for taking us through your top takeaways. But now, if you're somebody who's approaching the updated rules for the Inform for the first time, are there any resources that you recommend?
Yeah, so it depends on who the you is. I mean, if you're in-house counsel and you have a deal and, whatever, your CEO has sprung this on you and now you need to do something, I mean, the first step is definitely get counsel that knows this and can do this. The new rules are more substantive, and so it's not just a technical exercise. I mean, what you put in with your filing can have substantive implications on the deal or on the timing of the deal or the cost of the deal. So that's like kind of step one. But aside from that, I actually thought the FTC's instructions and some of the information they've published, kind of FAQ type stuff, has been quite helpful and kind of grounds some of this more concretely than if you were to just read the rules and try to go about pulling together a filing. So that's useful. What else? I mean, the pre-merger notification office, which is sort of the intake office at the FTC, publishes informal opinions. Those are useful. I mean, they're not gospel, and sometimes they kind of reverse, and but those can kind of give you some concrete, examples to look to, right? Someone might have had the same question you did several months ago, and you look, and the FTC has sort of weighed in on that. So that's useful. I think they stopped doing that, stopped issuing those opinions maybe in July or something of last year without explanation. Suspect it may have to do with the ongoing litigation, but there's still, kind of a corpus of informal opinions out there that are useful.
And has the PNO issued any other sort of guidance beyond the informal interpretations?
So they have a sort of a landing page that does have like FAQ type documents, and it's actually quite good. It's not a massive amount of information, but it really does, I think, do a pretty good job of explaining what the key issues are and how to think about them. So that's definitely, a go-to place. If you have a question, that should move the ball. You might, it might not answer every question, and then you got to talk to counsel, but that's like definitely a place to look.
Zach, you've provided a lot of incredibly helpful guidance and to like new practitioners, new to the forms, like steady hands. Is there any, out of all the things we covered today, is there a key point that you'd like to emphasize for practitioners and their clients?
Yeah, I would. I mean, early preparation just pays dividends. It can make what your first time might feel like a scary or intense process much, much smoother. You'll know exactly what it is you'll have to do. You'll know where to get the information to fill this stuff out. You'll have your contacts ready to go. They'll be aware of what they need to get to you. So that's like, I think the key learning. This is especially true if you're in a big company that has kind of data all over the place. I think if you're a smaller company, you might have things to think about because this is so new, but at least there aren't, armies of people you need to go find and talk to, right? So, but I think having that prep work, and it could be a lot of work if it's detailed, or it could just be like a session with counsel for an hour just to lay out what you would need to do, who you might want to talk to. That I think that's kind of a key takeaway.
Zach, thank you so much for taking us through the updated HSR rules. And now we want to get to know you a little bit better. So if you can tell us something about yourself that people don't know if they just know you professionally.
I have a somewhat recent obsession with soccer. I played, in high school, and I played earlier in life, and I liked it. I just wasn't like obsessed with it like I am now. I mean, I have a 7-year-old son who got very into it, and I think that reawakened the flame, or at least, maybe even more than that. got me really into it. So that's been, something that I will always be happy to talk to people about. If you want to talk about soccer, go Liverpool. It's not the greatest time for them right now, but that's okay. I play like in an over 30s league to the extent my body can keep up with it. So that's a fun fact.
All right. Well, now we're going to turn to a segment we call the Curious Hats.
And now it's time for the Curious Hat.
We're going to ask you a random question that you haven't been prepared on. So the question is, Zach, if you had $10,000 on the condition that you spend it all in 1 hour, what would you spend it on?
Oh my goodness. My gut reaction is I would get just a collection of really nice scotch is what I would do.
Money well spent, I'd say.
I agree. Thank you, Zach, for joining Puja and myself to discuss the updated HSR rules. And thank you to our listeners for joining us. I hope to see you next week.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.